Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's discussion. In this week's discussion, we're in session number 3 of our new program entitled Update on Trends in the Cumulative Trauma Injury Claim. And I sincerely hope that you've been with me through the first 2 sessions of this program, because the first 2 sessions have all been about laying some foundational and basic principles related to cumulative trauma injury claims. And in today's session and in the remaining sessions throughout this program, it's going to all start to come together for you, and you're going to have a sequence of aha moments as you begin to realize why it is that your phone rings for a request for your evaluation of so many cumulative trauma injury claims, whether those be evaluations that involve both a specific incident of injury and a cumulative trauma injury claim, or just singularly a singular cumulative trauma injury claim. And you're going to begin to understand what's happening behind the scenes, unbeknownst to you and unbeknownst to us as qualified medical evaluators, that creates the demand for so many of these evaluations. And today, you're going to have the first of a long series of aha moments, and the light bulb is going to go off, and you're going to start to realize what exactly is your role in these particular evaluations. So I have a fabulous program for you today. And before we get into the topics of today's discussion, let's just briefly review where we've come from so far in this program. In session number 1, we talked about the definition of injury as injury is defined in the California workers' compensation system. And it's important for you to understand exactly what is this definition, because the definition of injury in the California workers' compensation system may be different from how you define injury in your clinical practice. It certainly is much, much different. And when these cases come to us for our evaluations, many times they come to us as denied cases, and they require our opinion on compensability under Labor Code 4060. The denied case, these are denied cases that come to us. And as you sit face to face with your examinee, you're going to be trying to determine whether or not the examinee sitting in front of you has indeed suffered a cumulative trauma industrial injury. Well, in order for you to opine in favor of a cumulative trauma industrial injury, there must first be an injury, okay? Before you can have a cumulative trauma industrial injury, you must first have an injury. Before you can have an industrial injury, you must first have an injury. So as the examinee sits in front of you, before you can determine whether the examinee has a cumulative trauma industrial injury, you have to first determine, does the examinee have an injury? Because without an injury, there can be no industrial injury, there can be no cumulative trauma industrial injury. And injury is very specifically defined in the California workers' compensation system. And we went through the distinctions between first aid and medical treatment, and we described some of the distinctions between specific injuries and cumulative trauma injuries. And interestingly, both specific injuries and cumulative trauma injuries are conditions. They both have this in common. They both involve conditions, whether that condition was suffered in a specific incident of a singular injury or whether that condition was something that developed due to repetitive traumatic activities over time. Both of these types of injuries have in common that they both involve conditions that either cause disability and or cause a need for medical treatment. And that's the definition of injury as defined in the California workers' compensation system. The examinee must have a condition, and that condition must either cause disability and or a need for medical treatment. If the condition checks those 2 boxes, now we have an injury, and now we can determine if this injury is the result of industrial cumulative trauma or not. If the examinee's condition is not causing disability and is not causing a need for medical treatment, then by definition, it does not rise to the level of injury as injuries defined in the California workers' compensation system. So that was a very, very important session. If you missed that session, I encourage you to go back and re-listen to that session, perhaps with new ears, and take in the gems of wisdom contained in that session. In our second session, we talked about the dates of injury for specific injury claims and the date of injury for cumulative trauma injury claims. We'll talk a little bit more about the date of injury today for CT claims. And we also talked about what constitutes proper reporting of injury, what was a proper filing of an injury, and we talked about some of the statutes of limitation for both reporting and filing an industrial injury. The statute of limitation for reporting an injury is 30 days. The statute of limitations for filing for benefits for an injury is 365 days or 1 year. We're going to talk quite a bit more about date of injury and reporting and proper notice of claims, proper noticing of an injury claim in today's session. So that does bring us to today's session. In today's session, I want to talk to you about post-employment cumulative trauma injury claims. And if you remember, I should have provided it on this particular slide, but if you remember from our first two sessions, we cited some statistics from the Workers' Compensation Institute Review Board that talked about how many post-employment cumulative trauma claims are being filed on a monthly basis in the state of California. In fact, the most recent statistics on this number is approximately 30,000 claims, 30,000 claims, post-employment cumulative trauma injury claims are being filed in the state of California on a monthly basis. Now, I don't know how many people the Staples Center in Los Angeles holds, but I don't believe it holds 30,000 people. So that just gives you some perspective as to the number of these particular species of claim that are being filed every single month. Next month, there's going to be another 30,000, and the following month, another 30,000. And you're getting these cases, so you need to understand thoroughly how these cases come to you, and that's what I want to share with you in today's session. So with that as our introduction to today's discussion, let's continue where we left off on our last session. And today we're going to be in session number 3 of our new program entitled Update on Trends in the Cumulative Trauma Injury Claim. Okay, so let's begin. And in order to help you understand how it is that your phone rings for an evaluation that involves an allegation of a cumulative trauma injury when that claim is filed after the employment relationship with the employee and the employer has ended, we're going to go into some of the laws and labor codes that discuss this particular situation. And the first thing I want to share with you is Labor Code Section 3600. Now, we don't have time in today's session to go through every single section of 3600, and you should research this particular section of the law on your own because it's operative in almost every single one of your evaluations. Some section from this labor code is operative in your evaluations. So you should research this on your own time. But what I want to share with you today from Section 3600 are what are known as the affirmative defenses. Now, just a little background on Labor Code Section 3600. Labor Code Section 3600 is referred to as the conditions of compensation liability. What that means is this section of the law describes those conditions that are necessary for workers' compensation benefits to be owed to an injured worker. And the first few sections of Labor Code Section 3600 have to deal with some certain basics, such as number one, there has to be an employee-employer relationship. And sometimes you'll get cases where the employer is denying that the employee is even an employee. So there's a dispute over that particular section. Other sections, early sections in Labor Code Section 3600 talk about an injury having to arise out of and having to occur in the course of employment. And the first few sections of Labor Code Section 3600 talk about what conditions are necessary in order for compensation to be due to a worker who has suffered an industrial injury, okay? Well, in sections 4 through 10, these sections are known as the affirmative defenses. And these are the employer's out clause, the employer's escape clause, even in situations where the first several conditions, the first several sections are met, are established, that there is an employee-employer relationship, that an injury did occur, that the injury did arise out of employment and did occur in the course of employment. And there's no dispute over the injury and there's no dispute over the employment relationship. Still, the claim can be denied when certain situations exist. These situations are referred to as the affirmative defenses. And this is going to lead into what we're talking about today, which is the post-employment cumulative trauma injury claim. It's one of the affirmative defenses. But before we get to the affirmative defense that deals with our discussion today, let's just go over some of these affirmative defenses so you get a feel for the flavor of this particular section of the law, okay? So the first affirmative defense is where the injury is not caused by the intoxication by alcohol or the unlawful use of a controlled substance of the injured employee. So if the employer can demonstrate that the injury was in fact caused or contributed to by intoxication, by alcohol, by controlled substances, then the employer can escape liability under this section of the law. And this explains why injured workers are immediately drug and alcohol tested after an allegation of an injury. The employer is looking for the applicability of this particular affirmative defense. So that's the first affirmative defense that gets the employer out of liability, even in those situations where a bona fide incident of injury has occurred arising out of the employment and occurring in the course of employment. This is one of several escape clauses known as the affirmative defenses. Okay, so the first affirmative defense has to deal with intoxication, either by alcohol or controlled substances. The next several in order of the affirmative defenses are as follows. The employer can escape liability for a bona fide incident of injury arising out of and occurring in the course of employment if the employer can demonstrate that the injury is intentionally self-inflicted. And this theme, this self-inflicting of injury, is sort of continues throughout all of these affirmative defenses. In fact, it can be construed that our first affirmative defense, intoxication by alcohol or controlled substances, is an intentional self-infliction of injury by the examinee on the examinee. So this one is similar. Next one. Where the employee has not willfully and deliberately caused his or her own death. This deals with death cases. Basically, the interpretation of this section of the law is that suicides are most times disqualifiers under this section of the law, under this affirmative defense. There are exceptions for other suicides. When the suicide is directly related to an undisputed injury, the suicide may be covered. But this is an affirmative defense that the employer is going to raise in suicide cases. Next one is where the injury does not arise out of an altercation in which the injured employee was the initial physical aggressor. Now, of these three affirmative defenses, you're going to get this one, number 7. You're going to get this type of case. You're going to get this fairly frequently. For example, you'll be sent a videotape of some sub rosa videotaping, which shows some people involved in some type of an altercation, and you'll be given the opportunity to view the altercation and the opportunity to comment on the examinee's physical condition and injuries. And the issue of who was the initial physical aggressor is not a medical determination. But you can tell that this is what's operative in the evaluation, that this affirmative defense is operative in the evaluation when you're given these sub rosa videotapes. You can see what's going on behind the scenes and how the parties are strategizing that this claim is going to play out. And these types of injuries where the injured worker was or can be determined to have been the initial physical aggressor, you can argue that these types of injuries, again, are self-inflicted types of injuries. And these self-inflicted injuries throughout several different scenarios are not covered under workers' compensation law. There are affirmative defenses that prevent these types of claims for qualifying for compensation liability. Okay, and then the next two, before we get to the big punchline for today's discussion, the next affirmative defense has to do with injury being caused by the commission of a felony or a crime which is punishable by the penal code for which the injured worker has been convicted. I have not seen any of these types of cases, but this affirmative defense exists, and it makes sense. It makes sense. Employers do not want to be liable for injuries that are caused during the commission of a felony crime by the injured worker. This is an affirmative defense that allows the employer to escape liability for this scenario or for this situation. And then finally, and you're going to get these kind of cases all the time as well, where the injury does not arise out of voluntary participation in any off-duty recreational, social, or athletic activity that does not constitute part of the employee's work-related duties, except where these activities are a reasonable expectancy of or are expressly or impliedly required by the employment. And you're going to get these cases. You know, injured worker comes in and says he or she was at the company picnic, and there was a softball game going on, and the boss encouraged, implored, and almost even demanded that you participate in the softball game out of good spirit and good nature. And lo and behold, don't you know, unfortunately, as you round first base, heading for second base, you roll your ankle and you suffer an injury in an off-duty recreational activity. But your response to the affirmative defense is that your boss created a reasonable expectancy or impliedly required that you participate in that activity. But in this case, the employer is going to raise this particular affirmative defense to try and escape liability. And you can see that the dispute and the fighting can go back and forth multiple times before the issue is finally resolved. But we get these cases as qualified medical evaluators not for a determination as to the voluntary or involuntary activity, but rather for our AOE opinion on the injury and for our opinion on the examinee's medical condition. Okay, so for the purposes of our discussion today, the big picture is these are the affirmative defenses. The affirmative defenses are escape clauses for the employer to escape liability for bona fide injuries. Okay, the dispute is not over whether or not the injured worker employee has an injury. The dispute is not over whether the injury arose out of employment or occurred in the course of employment. These are defenses that apply in situations where there is an injury. Okay, there is an injury, but certain injury situations are disqualified under Labor Code Section 3600, and rightfully so, because for the most part, these are injury situations that are self-inflicted by the examinee. Not all of them are self-inflicted situations, but many of them are. And these are clauses that allow the employer to escape liability, where the next one deals with post-employment cumulative trauma injury claims and post-employment claims in general, is also one of the employer's escape clauses. Okay, and the next affirmative defense, Section 10, is what we deal with in these cases that involve cumulative trauma injury claims, especially when those claims are filed post-employment. So this is section number 10, affirmative defense number 10, and let's go over the language of this very, very carefully. It says, except for psychiatric injuries, which are governed by another section of the Labor Code. So this deals with all injuries, all conditions, all occupational diseases, asbestosis, cancer, pneumoconiosis, neuromusculoskeletal conditions, okay, everything except psychiatric injuries are governed by this particular section of Labor Code Section 3600. So it says, when the claim for compensation is filed, the filing of the claim, when it's filed after notice of termination or layoff, including a voluntary layoff, and we're going to go over these terms in just a minute, and the claim is for an injury occurring prior to the time of notice of termination or layoff, okay, which when else could the injury occur? Of course, the injury is claimed to have occurred prior to the termination or layoff. This is a case where the employee, the injured worker, is not claiming an injury after they were terminated or laid off. That, of course, would never be covered. They're claiming an injury, filing that injury claim after termination from the employment or layoff from the employment, and claiming that the injury occurred prior to being terminated or prior to being laid off. Okay, we get these cases all the time. Well, the law here says, it says, no compensation shall be paid. Now, I put this in bold and all caps. It doesn't appear this way in the language of the law, but I put this here for our benefit. The law here says, affirmative defense number 10 says that no compensation shall be paid. No compensation shall be paid. If you file a claim for an injury after you've been separated from the employment, whether that be by termination or layoff, and you claim that, hey, before I was laid off, before you fired me here, I suffered an injury. If you do that, no compensation shall be paid. You cannot file a claim for industrial injury after you've been terminated, okay, and say, and go back and say, hey, before I was terminated, I never said anything at the time. I thought it would go away. I was afraid of getting fired. And you'll hear these stories all the time. I never filed it because I was worried I would lose my job, or I thought it would go away, or I thought it would get better with time. If you do this, if you file a claim for injury after you've been terminated, no compensation shall be paid. It's the law. It's written here in Labor Code Section 3600. But then it goes on to say, unless. So here, after where it says unless, it describes some conditions where compensation can be paid. Okay, and let's go over it. It says unless the employee, okay, so the burden shifts now to the employee. It says unless the employee demonstrates by a preponderance of the evidence that one or more of the following conditions apply. We're going to go over these conditions in just a minute. It's important for you to understand that these conditions are the exceptions to the rule that no compensation shall be paid. Now, let's take a look at this very, very closely and go over some of these areas where potential disputes can arise. The first, and this is not a complete list, I'm just going through this little by little. It says the claim for compensation is filed after notice of termination or layoff. So you can imagine that there can probably arise disputes about the notice. The employee says, I never got notice. And the employer says, oh, baloney, we gave you notice. We have a copy here of the notice. And the employee says, well, I never signed anything. I never received this. And there can be this dispute simply over whether or not notice was properly given. And we're going to talk more about notice here in a minute. What about the next one? It says notice of termination or layoff, including a voluntary layoff. What is a voluntary layoff? We're going to talk more about what a voluntary layoff is, but it's quite confusing here what it means. What is a voluntary layoff? Is a person who quits their job, are they presumed to have delivered a voluntary layoff? What is a voluntary layoff? Can you imagine that there's disputes over the conditions or the circumstances of the separation of employee from employer? We'll go over this in a little bit more. And anyway, the point is that throughout this section of the law, there's multiple areas where disputes can arise, and that's why these cases come to us, because there are so many disputes. These are the types of claims that raise disputes, including medical disputes, and we're called in to resolve those disputes. So let's go over some of these exceptions, and we'll get specifically to the ones that apply to the post-employment cumulative trauma injury claim. Okay, so we're going to go over the exceptions to Labor Code Section 3610, the affirmative defenses dealing with the post-employment filing of an injury claim, whether that be a specific injury claim or a cumulative trauma injury claim. But before we do that, let's go over this dubious and ambiguous term of voluntary layoff. What exactly is voluntary layoff? If you think about what is the term voluntary layoff, you can imagine that this is a term that can cause great dispute in the system. Well, voluntary layoff was quite adequately described in one particular case that I want to share with you, known as the CJS Company versus the WCAB. And let me just give you some of the facts of the case so that you can understand this case and so that you can understand the concept of voluntary layoff, which is going to lead into the bigger concept of these affirmative defenses under section number 10. Okay. Well, with CJS Company, injured worker Fong was injured in a car accident in 1996, and like he was supposed to do, he immediately reported the incident, although he didn't claim any injury at the time, but he did immediately report the incident. That was in August 1996. Well, in September 1996, Fong quit his employment with the CJS Company. And the case doesn't tell us the circumstances of the resignation. It doesn't tell us whether Fong was a disgruntled employee. We don't know any of those particular circumstances. But we do know that on an administrative basis, he resigned his position voluntarily with CJS Company. He filed for injury benefits. He filed for workers' compensation benefits by claiming injury in 1997, June of 1997. So you can see here that the filing was within 12 months of the date of injury. In fact, it was within approximately 11 months. So both of the statutes, the statute for reporting the incident and the statute for filing the claim, are both within the statutes, right? The statute for reporting the incident is 30 days. The statute for filing the injury claim is 12 months. And here Fong complies within the statutory guidelines, within the statute of limitation guidelines. Well, the hearing officer, not the judge, but the officer that heard this case, denied benefits simply based on the post-termination defense, the affirmative defense under Section 10 of Labor Code Section 3600, which prevents, bars, blocks, bans, and prohibits the filing of claims post-employment. Okay, this exactly fits that scenario. Fong is filing a claim for injury after he's left the employer, and he's claiming that before he left the employer, he suffered an injury. Well, as we just reviewed, Section 10 blocks these claims. And on that basis, the hearing officer denied the claim. This is known as the post-termination defense. And you're going to see this language within the cover letters that you get, because we get 30,000 of these cases filed here every month in the state of California. So in this case, the CJS Company case, the dispute was not over whether or not Fong was injured. The dispute was not over whether or not the car accident occurred, right? AOE and COE. The dispute was over the term voluntary layoff. And as we saw from Section 10, claims that are filed following a voluntary layoff are blocked, are prevented, are prohibited by Section 10 of Labor Code Section 3600. And so the dispute was over the term voluntary layoff. The employer insisted that Fong tendered or delivered a voluntary layoff when he quit. Fong says, no, I did not voluntarily lay myself off from work, I resign from work, and those terms are different. So let's go to the case and see what the outcome of the case was. Okay, so here's the case, and let's go over the case, and we'll talk about what this case means in terms of our overall evaluations of these types of claims. So the pertinent facts in this case are few and undisputed, and we talked about this already. While driving a truck in the course of his employment, Fong crashed into a truck, stopped in front of him in rush hour traffic. He reported the incident right away like he was supposed to. He quit his employment in September 1996. He filed an application for benefits in June, less than 12 months after the date of injury. And in this claim, he alleged for the first time an industrial injury to his back from the accident. Now, the hearing officer denied benefits solely on the basis of subdivision A10 of 3600, which provides, as we said, and let's go through this again, which provides in pertinent part, where the claim for compensation is filed after notice of termination or layoff, that's what's referred to as the notice, including voluntary layoff. Now pay very close attention because we're going to get into voluntary layoff. And the claim is for an injury occurring prior to the time of the notice. No compensation shall be paid unless the employee demonstrates, and then they go into the 4 exceptions. And we're going to talk about those 4 exceptions here in a minute, but let's just focus now on the phrase voluntary layoff, okay? And let's go through and just get right to the conclusion of it. It says that it is not enough for the petitioners merely to cite legislative concern with fraudulent claims, and we'll talk about that in just a minute. The legislature may well have concluded that it is only fired or laid off employees who are sufficiently motivated to retaliate with a fraudulent claim. In the alternative, we must keep in mind that the end product of the legislative process is frequently a compromise. We should therefore hesitate to interpret language restricting the right to benefits as having universal application when the legislature itself specified only certain categories of former employees. Nothing on the face of the statute, and that's 3600 section 10, or in extrinsic sources supports the petitioner's interpretation that Fong tendered a voluntary layoff. We thus agree with the board that this statute, 3610, does not apply to employees who resign voluntarily. Voluntary resignation is different from a voluntary layoff. Okay, so let's go back now to our PowerPoint slide. Okay, so the first exception exists when the employer has notice of the injury as provided under Chapter 2, Section 4600. We went over that in our last session. That describes what actually constitutes notice of the injury. We'll review that here. So when the employer has notice of the injury prior to the notice of termination or layoff. So imagine the employee receives a notice of termination or layoff on December 1st. Okay, I'm making this up. Employee receives notice on December 1st, and the notice says that, hey, on December 31st, 30 days from now, the plant is going to be closing and you're going to be laid off. So the employee receives notice on December 1st. Well, if the employer has notice of the injury before December 1st, okay, then the employee is demonstrating that, hey, I'm not retaliating against you. I actually notified you. I notified you that I have had an injury. It has nothing to do with the being terminated or laid off. And these employees are protected these employees are protected because they're presumed to be not retaliating against the employer, and in fact, actual evidence of the injury actually exists. These are employees who are actually injured. They were actually injured before they received notice of termination or layoff, and this exception protects those employees. So let's just review what constitutes notice. Notice is described first in section 5400, which provides for a strict criteria for what constitutes notice. In 5400, it says that notice must be delivered in writing, and it must be signed by the injured worker or someone in the injured worker's behalf. So this is a strict criteria, notice in writing, signed. But then 5402 comes along and immediately softens the hard requirement of 5400 and provides for a much more liberal construction of notice. So let's talk about what 5402 says. 5402 is a very soft criteria. It says that knowledge of an injury obtained from any source on the part of an employer, the employer's managing agent, superintendent, foreman, or other person in authority. So let's just stop here. It says anyone in authority at the employer, at the employment location, anyone in authority who has knowledge of an injury obtained from any source, right? How? Like what source? Like obtained from the phone call of the nephew of the injured worker, or obtained by a post-it note supposedly left on the computer monitor by the injured worker. Knowledge of an injury from any source. I told my supervisor. I told human resources. I told the night manager. You'll hear these stories. Injured workers will tell you that they provided knowledge. What they're doing is they're confirming that they provided knowledge. They're confirming that their notice of the injury satisfies this section of the law, which is very, very liberal. So let's go through it. Or knowledge of the assertion of a claim, right? The management starts to get knowledge, starts to hear through the grapevine that Betty Smith is claiming that she injured herself while pruning the grapevines at the vineyard, okay? Knowledge of the assertion of the claim. Sufficient to afford opportunity to the employer to make an investigation into the facts is sufficient to service under 5400. So this is a very liberal definition of notice of the injury. And you can imagine that this is an area of great, great dispute where the employer is going to contend that, hey, we never had any notice. And the employee is going to say, oh, yeah, I gave you notice. In fact, I had my wife call into the evening supervisor and even tell the evening supervisor that I hurt myself on the job. So if notice can be established, then this exception protects injured workers, and benefits by law are payable to the injured worker. So Labor Code Section 5402 provides for a very liberal interpretation of what constitutes notice of injury. Well, some case law have further clarified what constitutes notice, because as you can imagine, this is an area of great, great dispute between employee and employer. And one thing we know from case law is that notice must be communicated to some person in authority. And you can imagine injured workers claiming that they provided notice by telling the night security guard or my work partner in janitorial services, okay, or a variety of other people, not persons in authority. But we know from case law that it must be communicated to at least a person in authority at the company. So for one particular case, UPS versus White, communication to a union representative did not constitute notice and was insufficient to constitute notice because the union representative was determined to not be a person in authority. QUEVA versus the WCAB, communication to a non-managerial co-employee or co-worker. And you'll hear injured workers tell you, yeah, I told my co-worker, John. I told my co-worker, Betty. Okay, I told a co-worker that I hurt myself. And case law indicates that a co-worker is not a person in authority who has the opportunity to investigate the facts, okay? It's not sufficient to constitute notice. Finally, the Wagner case. With the Wagner case, the employer has a duty to investigate the injury when the employer is reasonably certain. Okay, this goes back to the assertion of a claim for injury. When the employer is reasonably certain that an injury is being asserted, they have a duty to investigate the injury because a reasonable certainty, a reasonable assertion of injury is equivalent to notice under 5402. Okay, so this is sort of a long-winded way of saying that exception A to the post-termination defense, the affirmative defense, is that when the employer has, in fact, has notice of the injury before the notice of termination or layoff, benefits shall be provided. Okay, so that's the first exception to this affirmative defense of the post-employment filing of injury claims. The second defense under Section B, the second exception to the prohibition against the filing of claims post-termination, is when the employee's medical records, which exist prior to the notice of termination or layoff, contain evidence of the injury. And I've had this case before myself, where an injured worker was working for a retail establishment. The injured worker was laid off from the retail establishment and then went into her own business and later filed a claim for industrial injury during the period of employment. And of course, the employer raised the post-termination defense, but all in the year preceding that termination or layoff, the injured worker, the employee, was receiving medical treatment for the same conditions for which she claimed industrial injury. And her medical records indeed described symptoms related to the workplace duties and medical treatment being rendered. So she had the medical records that existed prior to the notice of termination or layoff, and she was protected. Now you might ask yourself, why is she protected? She's protected because she actually suffered an industrial injury, but for whatever reason, and who knows the motives of employees and injured workers, for whatever reason, she never filed it. She never raised the issue. She simply pursued medical treatment on a non-industrial basis. But in her case, she was provided benefits because she had the medical records. Okay, we have a couple of cases that illustrate this principle. In one case, the existence of pre-termination medical records showing an injury is sufficient even if the records do not establish industrial causation. And you'll find this. You'll find medical records that make no reference at all to workplace duties, but the industrial causation connection is not necessary. The only thing that's necessary is evidence of an injury condition. Okay? In another case, the evidence of injury, right here it says evidence of injury. So in this case, the evidence of injury existing prior to the notice of termination need only be evidence of the employee's medical condition, some medical condition, and need not be evidence of the actual causal connection between the applicant's condition and the employment. And this will bring cases to you for your determination, for your opinion as to the industrial causation. You can see that this in and of itself is a great source of evaluations for us as the Qualified Medical Evaluator. Now, the next exception, which is described in Section C, has to deal with specific incidences of injury. And let's pay close attention to this. And we'll talk about why this exception exists. It says, the date of injury, as specified in Section 5411, And 5411, you remember, deals with the date of injury for specific injury claims. When the date of injury is subsequent to the date of the notice of termination or layoff, but prior to the effective date of the termination or layoff. So this exception applies to specific injuries that occurred before the effective date of termination or layoff. Now, why would there be this exception? Okay, this exception exists to protect people who get a notice of termination or layoff today and tomorrow fall off the scaffolding and hurt themselves before the effective date of the termination or layoff, which is going to be in 30 days or 60 days or whatever. So let me give you an example. The employee receives a notice of layoff on 10/1/21. And the notice of layoff says, hey, it says very shortly, in a month or two, and in this example, I have the effective date of termination or layoff being 12/1. The notice says on 12/1/21, the company plant is closing, and you're going to be laid off on 12/1/21. Well, then, unfortunately, the injured worker 30 days later, 30 days after the notice of termination or layoff, but 30 days prior to the effective date of termination or layoff, gets injured in some way, shape, or form. It's in a car accident, slip and fall, repetitive stress, whatever. This deals with specific incidents of injury, so we should rule out repetitive stress. Okay, forget I said repetitive stress. But car accident, slip and fall, lifting injury, whatever, and this is before the effective date of termination or layoff, this person is protected. The reason this person is protected is because people can actually get injured in this time period. And the greater the time period between the notice of the termination or layoff and the effective date of the termination or layoff, the greater is the likelihood of suffering an injury during this period of time. And this exception protects employees who are injured in this particular scenario. And the final exception to 3600 Section 10, the post-termination affirmative defense, is found in Section D, which deals with cumulative trauma injury claims. So we're now at the crux of the matter, the post-employment cumulative trauma injury claim. And here you're going to see why so many of these cases come to us for our evaluations. It tells us that persons who have the following scenario are protected and qualify for benefits. Okay? It says when the date of injury, as specified in Section 5412, and we went over that section in our last session, and we're going to go over it again here in just a minute. When the date of injury is after the date of notice of termination or layoff. Isn't that interesting? So you remember the date of injury for cumulative trauma injury claims is when there's a collision or a coincidence of two factors. Number one, disability, and number two, knowledge that the disability was due to the present or prior employment. It's written into the definition that it can apply to prior employment, right? And after you've been terminated from your employment, that old job that you used to have is your prior employment. When the date of injury is after the date of notice of termination or layoff, benefits can be delivered. And you can imagine that this is an area of great dispute. So let me give you an example. Using the same dates as in our prior example, employee receives notice of termination or layoff on October 1st, and then again, the effective date of layoff is December 1st, 2021, within the same year, okay? And during this time period, no mention, no filing, no reporting of an industrial injury. But then later, and here in this case, it's 6 months later, and it can be 6 days later, 6 weeks later, 6 months later, 6 years later. I've seen claims filed a decade after the effective date of termination or layoff or retirement, even in some circumstances. This date can be at great lengths removed from the effective date of termination or layoff. And when the date of injury can be established after the effective date of, or after the notice of termination or layoff, benefits can be applied. Benefits are qualified for. The injured worker does qualify for benefits. And it all has to do with the date of injury and the definition of date of injury. So let's review that before we conclude today's discussion. Okay, so let's review the date of injury as relates to these post-employment cumulative trauma injury claims. Labor Code Section 5412 says, and again, this is a review, the date of injury in cases of occupational diseases or cumulative trauma injuries is that date upon which, number one, the employee first suffered disability therefrom, and here's number two, either knew or in the exercise of reasonable diligence should have known that such disability was caused by his present or prior employment. And this is where the post-employment claim comes in. And this is where the post-employment claim flies or survives or succeeds as a claim. Because in general, under Labor Code Section 3600, these types of claims are barred, banned, blocked, and prohibited. But here is an exception that allows this type of claim to succeed. So let's illustrate this. Again, we have an injured worker who receives a date of notice of termination or layoff on October 1st. The effective date is on December 1st, 2 months later, and then files a claim at some point later, and the date of injury is established 6/1/2022. This is the date upon which the employee either first suffered disability and knew that the disability was caused by his or her prior or present or prior employment. We're going to talk about both of these components, the disability and the knowledge of the disability, because both of those are great areas of dispute, I'm sure you can imagine. We'll talk more about those in our next session, but for us as qualified medical evaluators, you'll notice that out here, this is where we see the injured worker, the examinee for the evaluation. Many times it's us as qualified medical evaluators that establish the disability, that we help establish the date of injury, because we can contribute to the knowledge, the knowledge that the injured worker's problems are due to the present or the prior, in this case, the prior employment. We help contribute to the knowledge. We can also establish the disability in terms of either temporary total disability at this time or even permanent disability at this time. So out here, this is where we come in as qualified medical evaluators. Many times it's us as the qualified medical evaluators that establish this date of injury out here, that help establish this date of injury, which then allows this claim to fly as the exception D, under the general affirmative defenses under Labor Code Section 3610. So this is where we come in as qualified medical evaluators. We have no determinations back here. We have no determination back here. We don't control or comment on any of the factors back here. It's out here where we evaluate the injured worker and determine, number one, if an injury exists, an injury exists, number one. Number two, whether or not that injury is causing disability and or a need for medical treatment, which then qualifies it as an industrial injury and helps to establish this criteria of a date of injury subsequent to the date of notice of termination or layoff, and even subsequent to the effective date of termination or layoff. So this is where we come in as qualified medical evaluators. So doctors, isn't that fascinating? Isn't it fascinating that this exception serves as the great loophole through which many claims can survive the affirmative defense of Labor Code Section 3600, Section 10, which in general blocks, bans, and prevents the filing of claims post-employment, post-termination. Okay? In general, these claims are blocked. And they're blocked because the legislature has long known that employees want to retaliate against the employer when they're laid off, when they're fired. And the legislators have passed this law to prevent this retaliation. But there are certain situations and scenarios where injured workers need protection when they actually have suffered an injury, but for whatever reason just never filed it until after separation from the employer. Now, this makes great sense in the case of occupational diseases, right? A lifeguard does lifeguarding for 2 summers in a row and then goes off to college and onto a career, and 3 years later develops skin lesions and diagnosed with skin cancer. And it's the dermatologist who informs the lifeguard, the former lifeguard, that, hey, this skin cancer is caused by that time when you were a lifeguard. And the lifeguard has the knowledge or the realization at this time, this is now 2 years after his last day lifeguarding, now has the realization that, hey, this disability, this need for medical treatment, this need to wear long sleeve clothes now was caused by my prior employment. And this exception, exception D, allows the lifeguard to file the claim long after his or her last day of lifeguarding. So it makes great sense in the case of occupational diseases. Well, this exception also applies to cumulative trauma type of injuries, the neuromusculoskeletal and even internal medicine type of injuries that accumulate over time but do not manifest themselves until long after the effective date of notice of termination or layoff. So this is the great loophole, and you're going to be evaluating many cases where this scenario, this exact scenario, is operative. The injured worker and their attorney, the applicant attorney, are attempting to establish the date of injury under Labor Code 5402 as occurring after the notice of termination or layoff. And this is what brings these cases to us for evaluations, because these are the types of cases that the claims administrator just immediately denies in order to, as we talked about earlier, stop the bleeding from the $10,000 under the $10,000 rule under Labor Code Section 5402. So when you understand what's happening behind the scenes, you understand what's operative in your evaluations. Your evaluations concern a very few limited, finite number of issues. Number one, is there injury? And then number two, is there disability? Is there either a need for temporary disability or is there any permanent disability? And if these criteria can be met, this claim can survive. So doctors, I hope this helps you. We'll talk more about how to manage these cases, and there's an exact algorithm for evaluating post-employment cumulative trauma injury claims. But for today's session, it's important that you understand what brings these cases to you in the first place. So I want to thank you for taking the time to join me on today's session. I look forward to being with you on our very next session as we continue our ongoing series entitled Update on Trends in the Cumulative Trauma Injury Claims. For now, I want to thank you for your commitment to excellence. I want to thank you for your service to California injured workers, and I'm wishing you best of success in your career as a qualified medical evaluator.